In this session, we are going to look at the almost criminals, attempt as a preliminary offence. So what exactly is an attempt? Let's start at the top. Imagine someone is planning a heist but gets caught before grabbing any loot. Are they off the hook? Well, no. The law recognises inchoate offences, and these are incomplete crimes where someone tried but failed to do something illegal. The statutory definition comes from the Criminal Attempts Act in 1981, Section 1(1). If, with intent to commit an offence to which this section applies, a person does an act which is more than merely preparatory to the commission of the offence, he is guilty of attempting to commit the offence. So if you intend to break the law and take a concrete step towards that, but don't see it through, you can still be found guilty of an attempt. And this covers indictable and either way offences. So what do you have to prove? Actus reus and mens rea. Like most crimes, attempts will have these two parts. So the actus reus, of course, is the conduct or what the defendant did. And the mens rea is the mental state or what they intended. So the actus reus, what does more than merely preparatory really mean? Well, the phrase at the heart of the law on attempts is more than merely preparatory. The defendant, in other words, must go beyond just planning or getting ready. They've got to actually take a real step towards the crime. Think of it as moving from the thinking about it stage to the doing something about it stage. Let's take a look at some classic cases. We've got R versus Gulliver from 1990. So Gulliver jumped onto a racetrack to disrupt a race so he could reclaim a losing bet. But the court found he hadn't done enough to count as an attempt. The court said the defendant must have embarked on the crime proper. So jumping onto the racetrack to try to stop a dog race in order to get your money back isn't quite enough. More action is needed. Then we have R versus Geddes from 1996. In this case, a man lurking in school toilets with a knife, tape and rope wasn't considered to be attempting kidnap. He was still at the preparation stage. So he was not found guilty of attempt. The court decided that his actions, while, yes, very odd and suspicious and very concerning, had not gone beyond mere preparation. He hadn't actually tried to approach or detain anyone, so he hadn't moved into the attempt phase under the law. And finally, we've got R versus Boyle and Boyle. Here, the defendants were caught outside a house with broken door locks, showing they had moved from preparation to actually attempting burglary. Breaking a lock to get into a house, well, that's more than just making plans. That's attempting burglary. So, as a top tip, you need to ask yourself, has the defendant moved past preparation and started to carry out the crime? And if that's a yes, well, it's likely to be an attempt. Moving on now to the mens rea. What was the defendant thinking? So attempt is all about intention. The defendant must mean to commit the full offence. Being reckless or careless won't cut it here unless that's specifically part of the crime itself. Let's take a look at some key cases. We've got R versus Wybrow from 51. Here, the defendant wired an electrical device to his wife's bath and caused her some serious harm. For attempted murder, you have to prove they intended to kill, and causing serious injury, GBH, doesn't count. Then we've got R versus Esom. If someone rummages through a bag looking for something to steal but hasn't decided what, it's not an attempt. So without firm intent, it doesn't count. And finally, we have A to G's references, numbers 1 and 2 of 1979. Here, if the defendant intends to steal anything worth taking, that's enough. Conditional intent can still amount to attempt. So in this case, the defendants had rummaged through property, as in the previous case, looking for something valuable to steal, but hadn't decided on any particular item beforehand. And the court held that this conditional intent, the intention to steal if something valuable or suitable was found, that was sufficient for an attempt. And it clarified that you don't need a fixed target for your crime. As long as you would have stolen something of value if you found it, your actions can amount to attempt. Let's have a look at some practice scenarios. Defendant brings a weapon to a bank, but is stopped outside. So this is probably just preparation and therefore wouldn't count as attempt. Defendant breaks into a shop window, tries to climb in but is caught. Well, that's more than preparation. It's likely attempted burglary. D points a gun at victim and pulls trigger, but the gun jams. Well, that's an attempt, and maybe even an impossible attempt. We'll have more on that shortly. Attempting the impossible. So here's a cool twist. You can still be guilty of attempt, even if the crime was impossible to complete. This is from Section 1(2) of the Criminal Attempts Act 1981. And it says that you can be found guilty if you try to commit a crime that's actually impossible, like trying to pickpocket an empty pocket, for example. The famous case is the Shivpuri case, where someone tried to smuggle in to the country what they thought were drugs, but actually they weren't drugs. They were just vegetable matter. And the court said, as long as there's intent and more than mere preparation, it counts as an attempt, even if the crime couldn't actually happen. Let's consider, is the law fair? The law on attempts punishes people who don't finish the crime, but take dangerous steps towards it. This is meant to protect society and reflects the idea that making a clear and deliberate move towards a crime is still blameworthy, even if that plan flops. But it's not perfect, because the line between preparation and attempt is really fuzzy. For example, Geddes was found not guilty even though he was lurking around with some very suspicious tools, but he hadn't done enough. And some legal experts, and probably a few confused jurors, feel the law needs clearer rules about when exactly preparation turns into attempt. Policy-wise, the law tries to balance stopping dangerous people and avoiding punishing those who've really only just started making plans. Here's a quick reference table, which you can pause and take a bit of a closer look at. And a final thought. So that's it for attempts. Remember, it's all about intent and actions that cross the line from planning to doing. If you can spot those magic words, more than merely preparatory, you're halfway to legal glory. Keep practicing, keep revising, and you'll get there.